Good evening and welcome to Pendle Hill's first webinar in the series, Working Towards Right Relationship with Indigenous Peoples. Tonight's webinar is entitled Sovereignty and Tribal Government Relations with the United States and Canada. Before we begin, I wish to acknowledge gratefully that Pendle Hill is situated on land in Lenape-Hoking, the traditional homeland of the Lenni Lenape people for at least 12,000 years before European contact. Lenni Lenape means original people, and they are respected as the grandfathers by other Native Americans. Lenape-Hoking occupies rather a large territory, stretching from the source of the Delaware to its mouth and taking in the Schuylkill and the Lehigh river systems in what is now eastern Pennsylvania, all of what is now New Jersey, a large northeastern swath of what is now Delaware, and the entire Hudson River Valley, both sides, from a point above Albany to its mouth, and including all of New York City and the western tip of Long Island. Within the first 100 years of contact, an estimated 80% of the population of the Lenni Lenape died of violence or disease. And as European colonists settled in this area in greater numbers, most of the Lenni Lenape, now more commonly known as the Delaware, were pushed west, first into areas in western Pennsylvania, and then into the Ohio River Valley in Canada. And later Indian removals scattered different elements of the Lenape into Idaho and Wisconsin, Missouri, Kansas, Oklahoma, and Texas. However, some Lenape people stayed behind in Lenape-Hoking, hidden in plain sight. Today, there are 3 state-recognized Lenape tribal nations within the original Lenape-Hoking. The Nanticoke Lenni Lenape Nation near Bridgeton, New Jersey, the Lenape Indian tribe of Delaware in Cheswold, Delaware, and the Ramapo Lenape Nation near Mahwah, New Jersey. Pendle Hill is grateful and honored to be in a growing relationship with the tribal leadership of these tribal nations. This evening, I would like to invite us to begin with a traditional way that Quakers gather when they are about to hear expectantly the words of the Spirit being spoken to them as they gather in a period of silence. This is our way of inviting the Great Father, the Great Mother, to speak to us, to clear our minds and hearts and make them as one as we hear tonight's presentation. So please join me in taking a moment of silence, collecting yourselves and being prepared to listen to our speakers with open hearts and minds. Thank you, friends. It also does us well to acknowledge that yesterday, August 9th, the world celebrated the International Day of the world's Indigenous Peoples. And one can hardly imagine a better way than to begin our first webinar in the series working towards right relationship with Indigenous peoples than to have that as a prelude. This evening, we will be addressing sovereignty and tribal government relations in the United States and Canada. Before I begin, I'd like to thank our co-sponsors, Canadian Friends Service Committee, Decolonizing Quakers, and Towards Right Relationship with Native Peoples, a program of Friends Peace Teams. I would also like to take this opportunity to thank members of the Planning Committee and Pendle Hill staff. The Planning Committee of Paula Palmer, Sandra Boone Murphy, Jennifer Preston, Judith Brown, Ruth Flower, Buffy Curtis, Lisa Lee Haynes, Peter Clay, and our host, Francisco Burgos, the Director of Education at Pendle Hill, and also on the Pendle Hill staff, Melissa Bennett, Lena Blunt, David Butterworth, and Eric Evans. There are in excess of 350 people tonight, or there will be, and many last-minute registrations came in, and so it took the whole team to get everybody organized. Several people encountered some difficulties in saying that they did not receive the connection information. As I know that I sent this to everybody who was registered, and I received very few bounces back, probably due to a typo error. I would ask that for the future, you list me as someone safe to receive emails from, because chances are, since I was sending a lot of blind copies, that this may have gone into your spam folder if you didn't receive it. A couple of notes on tech. Behind the scenes, Francisco Burgos will be our host. You are muted and will not be able to unmute yourself during the call this evening. If you encounter any problems, please use the chat feature to inform Francisco of your problem so he can correct it. As questions arise, you are also invited to write them in chat and send them to Francisco. You cannot chat with other people on the call. All chat messages will go only to our host, Francisco, and he will, I'll be the moderator for asking questions in the question and answer period, but Francisco will send those to me. This evening's webinar, as others in the series, will be recorded. It is being recorded now, and it will be made available to registrants at some time in the future after it has been reviewed and edited as necessary. Registrants will be notified when the recording becomes available, as we know that some of you are not able to attend all sessions. In addition to the 2 articles that I sent out in the connection invitation this afternoon, we expect soon to be able to post a list of our sources that will be lengthier, along with some queries to guide further self-education and self-reflection. There will be 2 opportunities during the course of the series for participants to gather for discussion in small groups via Zoom. One will be on Monday, September 21, again at 7:30 p.m. Eastern Time. And now it is my pleasure to introduce our speakers. Jerilyn DeCoteau is an enrolled member of the Turtle Mountain Band of Chippewa Indians in North Dakota. She received her law degree from the University of Oregon, and as a lawyer, she has pressed for the rights of Indian tribes to govern themselves, control their resources, and ensure human rights for their members. She practiced Indian law at the Native American Rights Fund, the U.S. Department of Justice, and for her tribe. She was director of the Indian Law Clinic at the University of Colorado and has taught Indian law courses at Yale, the University of Denver Law School, and at the Turtle Mountain Community College. Jerilyn co-directs Toward Right Relationship with Native Peoples, a program of Friends Peace Teams. She is a co-founder of Right Relationship Boulder, and she was instrumental in establishing Boulder's Indigenous Peoples Day. She currently serves as Chief Justice for the Pueblo of the San Ildefonso Supreme Court, and she consults on issues of tribal governance, capacity building, and the legacy of the Indian boarding schools. She is a past president of the board of directors of the National Native American Boarding School Healing Coalition. Our speaker, the second speaker we have with us this evening, is William David, who is currently the Director of Lands, Territories, and Resources with the Assembly of First Nations in Canada. He holds a degree in environmental engineering science from MIT and a law degree from the University of Ottawa. Mr. David has over 20 years of experience working to advance the rights of Indigenous peoples at the community, national, and international levels. He has served as a director for Mining Watch Canada and is currently a director with Nature Canada. Our panelists have elected to have our friend Jerilyn DeCoteau speak to us first. Jerilyn, welcome. We're so glad to have you with us.
Well, thank you, John. Thank you so much. And thank Pandal Hill for the whole series that you have planned. I think this is the first of that series. I am absolutely overawed and humbled knowing that there are 350 plus people who have registered for this. That's very impressive. It's a little scary, but I have to say that Zoom is an amazing product because it allows us to connect in this way and to do this work together in, I think, a much more impactful way just by virtue of numbers. And hopefully it will still retain some of the interpersonal quality of an in-person meeting. So I'm really grateful to be able to talk to you tonight about tribal sovereignty and the relationship that the tribes in the United States have with the federal government here and with the states and with other tribes. So thank you for that. You did give us a list of questions, and I think I'll touch on some of, maybe not all of them right now, but at least the introductory kinds of questions. And maybe I'll just start with the number of tribes that are here in the United States. We have about 574 federally recognized tribes, and 229 of those are in Alaska Native villages. There are 326 federal Indian reservations, so that's land. And the Little Shell tribe of Montana was the last tribe to be recognized, and that happened just recently in I think December of 2019, and I actually went to their celebration. So they're related to my tribe because Little Shell was our traditional Chippewa chief too, and Little Shell refused to sign the treaty by which the government took our lands in North Dakota, our 10 million acres, for 10 cents an acre. So we always call it the 10-cent treaty. Anyway, the Little Shell, Chief Little Shell left. He said he wouldn't do it. He had gone to Congress and argued against this and then lost and took his people who wanted to follow him and went to Montana. And they've been known as the landless Little Shell ever since. So they now have federal recognition, which have been fighting for since I started work at NARF before. Probably I was 1984, I think they had already begun that effort. And they will get some land. And land is an essential component of sovereignty. So that is a very important piece for any tribe to have people and land, territory that they have authority over. So yeah, that's pretty exciting. There are also unrecognized First Nations. There are about 400 of them. I had to look that up. I was surprised. 400 non-federally recognized tribal entities in the US, and lots of those lost their tribal recognition during the termination era. So this was an era in the 50s and the 60s when the federal government decided it was going to get out of the Indian business and terminate the relationship that it had with, and there were about 100 tribes. My tribe was actually slated to be one of those tribes, but through some very skillful resistance and negotiation, we were not terminated. So anyway, some of those tribes have lost their federal recognition. Irony of irony for them is there is a process to become federally recognized that the Bureau of Indian Affairs in the United States has set out. And there are hundreds of tribes, probably all 400 of these, trying to get federally recognized. But those tribes who were terminated aren't eligible to become recognized. And it just sounds so grim. There is an avenue for them, though. They can seek what the Menominee tribe, the Klamath tribe, and some other tribes in the United States finally achieved after they were terminated, which was a restoration, a re-recognition of their tribal status. So that has to happen through a congressional action. The recognition process is an agency action. You have to go through the Bureau of Indian Affairs. So there are different paths, both pretty fraught for sure, to achieve recognition if you're not a recognized tribe now. Yeah, 16 states have tribes that they recognize that are not federally recognized. So that's important to remember too, that there are various kinds of status, but the most beneficial status is federal recognition. So that's kind of my spiel about the tribes that here. Sovereignty. So sovereignty does require a people, it does require land and your ability to govern, your authority over that land, to govern and do all aspects of governing that any country, any sovereign would do. And tribal sovereignty has always been recognized by the United States. And it's been recognized in treaties, it was recognized in the Articles of Confederation, it was recognized again in the Constitution of the United States, because it refers to treaties with Indian tribes. And treaties are made between nations. And so there's always been a recognition of tribal sovereignty. And it's kind of funny the way that there were a lot of early cases in the United States that dealt with tribes and their territories. And lots of times it was because of conflicts with states, Georgia, Worcester against Georgia. So Worcester was a case where there was a minister, I guess, a preacher or something, who hadn't registered with the state to be able to go into Cherokee territory in Georgia. And so Georgia got upset about that, and it brought a court case. And the Supreme Court said that the tribe, the preacher didn't have to register with the state of Georgia because the state of Georgia's laws had no effect in Cherokee territory within the Cherokee Nation, that it was a distinct political entity of its own. So it kind of sounds like it was a dispute between Cherokee and Georgia, but what it really was, think about this really early in our country's history, in the United States' history, it was a contest between federal authority and state authority. Who had say over what? So the United States was making that very important federal principle clear, not just with respect to tribes, but it would come up in other situations. Who's got the authority in a particular situation, whether it involved Indian nations or not, the state government or the federal government. And these things were very much evolving because it wasn't always crystal clear in the Constitution. So yeah, that's kind of what that case was about. But in that case, again, the Supreme Court, then another branch of our government, recognized tribal sovereignty over their own people in their own territory. And the laws of Georgia could have no effect. So it established this principle that states didn't have any authority in Indian country. And that principle stands to this day, unless Congress passes a law, that then it becomes a federal authority that a state would be exercising. And the other principle that was established in those early cases, and they're called the Marshall Trilogy. Another principle that was established there is that even though tribes were independent political entities, they were also domestic nations under the tutelage and the wardship of the United States of America. So federal law and that relationship has rolled out from there, and it hasn't always been clear, and it hasn't always been easy. It's been fits and starts. More often than not, tribal sovereignty has been chipped away at over the years, and we can talk a little bit more about that. Well, one of the first cases that came up was Lone Wolf. I'm trying to think of what tribe, the Lower Brule tribe. An Indian killed another Indian, and the United States wanted to prosecute, or maybe it was a state. Anyway, and the defendant said, you don't have any jurisdiction in Indian country. And the court agreed. And they said, yeah, you're right. You know, this is an independent tribal nation, and the United States doesn't have jurisdiction over what happens between tribal members. So that was that, right? That was in 1883, I think. So in 1885, Congress said, oh my God, we can't have that because, you know, the Indians don't have capital punishment and they don't do things right. So if we really want to be sure that there's justice in Indian country, then we need to do something about it. So they passed a law called the Major Crimes Act, and it extended federal criminal jurisdiction over a category of crimes like murder, burglary, I can't remember what they are, serious crimes. And so Congress did that. So the very next year, there was another case that tested the constitutionality of that law because there was no apparent basis. There was no apparent basis for the authority that Congress was exercising because tribes had been recognized as independent nations with the right to create their own laws and their own justice systems and punish their own people. And there were no non-Indians involved in this. So the court said, well, the tribes are wards of the United States. So their sovereignty is limited in this way. The US government has what they call plenary power over tribes. It's kind of a funny thing that they use that because plenary power really referred to the Commerce Clause in the Constitution. And the Commerce Clause is one of the two places where tribes are mentioned when it says that the United States has the authority to regulate commerce with Indian nations, So to extrapolate from that and say that they now have that same power and authority over criminal jurisdiction on reservations was quite a stretch. And it was really a policy-based argument. And from that plenary power doctrine, it was a floodgate of decisions for the next 2 centuries that would serve as a basis for diminishing tribal authority. And the test sort of always became a balancing of interests, a balance between tribal interests or state interests, or Indian citizens and non-native citizens of states. So there was always this balancing, and when you do that balancing, it gets to be a little bit subjective. So it really turned out not in our favor too many times because of this really unconstitutional, or extra constitutional at least, plenary power doctrine. So that's been a real limit on sovereignty. But the basic tenets still apply. There is a government to government relationship with the federal government. States have no authority within the boundaries of Indian country unless the federal government has passed some law that says they do. These are truths that have held, and also the trust status that's been put forth as another basis for the application of this so-called plenary power, that, that there's a trust relationship between the United States and the tribes. So those things have sort of held in place. That doesn't say they've upheld any treaties, because they haven't, and there's been a recent case on that we'll probably get to talk about a little bit later. And I'm not sure how much more I want to say, because some of the questions that you've offered us are a little bit more particular in the way that tribes are able to exercise their sovereign or not able to. So I think I'll just stop there and let Will have his turn, so that we have enough time for people to ask the questions they're curious about. Thank you.
Thank you. Welcome, Will. We're so glad to have you with us.
I'm thrilled to be here. Thanks a lot. And before I start, I'd just like to acknowledge the traditional and unceded territory of the Algonquin Nation, where I am tonight. And I'd also, again, just like to thank you, John and Pendle Hill, as well as all the participants tonight, for your time, for arranging this, and for listening. And I just say that because one of the things that I found particularly helpful in this work, particularly in political advocacy, is just building greater understanding of who Indigenous peoples in Canada are, as well as not only what Indigenous peoples are seeking, but also how they would profess to seek that. And I only say that because a lot of the questions and issues that we get into in Canada very quickly become very loaded issues, and are very, very contentious, or can be. I guess I'd start just by noting a couple of things about Canada that are just helpful to keep in the back of your mind. The first is that the country came together a bit later than the United States, in about, let's say 1867. Like a lot of the things I'm going to be talking about tonight, it's not entirely clear to me that that's a rigid date. But what did happen at that time was that the Canadian, what was then the Canadian federal government, Canadian provincial governments, all got together and decided to strike themselves a list of powers. So I'm not sure the provinces were terribly involved there, but what's consequential for this is just to note that after witnessing what I suppose people perceive to be the ambiguity about state and federal power in the United States, made a list in Canada of various subject matter jurisdictions which the federal parliament or the various provincial parliaments would have complete jurisdiction in terms of lawmaking over. That's important for this purpose only because one of the things that the federal government took jurisdiction over was lands, or I should say Indians and lands reserved for the Indians. That's section 9124 of the British North America Act, sometimes called the Constitution Act 1 in Canada. It's important because one of the things that Indigenous peoples in Canada broadly have been seeking since really since contact, but particularly since the formation of the Canadian state, has been recognition and to some extent implementation. And that can be anything from recognition of individual identity to recognition of collective identity, recognition of nationhood, of sovereignty, of treaties, even of just of our general existence. The first thing the federal government did with its power under Section 9124, that's the Indians and Lands Reserved for the Indians power, was to create an act which is now known as the Indian Act. The purpose of the act when first drafted was essentially to enfranchise all Indigenous peoples in Canada and the Canadian state, to make us all Canadian citizens, removing distinct identity. I should say that the act actually has gone through various iterations. And although that may have been the policy objective, there's been no shortage of resistance throughout Canada's existence to assimilationist ideas, to enfranchisement, both within and outside of really the Indigenous community. Recognition is important in the context of the Indian Act because there are 3 Indigenous peoples or groups of peoples in Canada, one of which is First Nations, also referred to in that particular act as Indians. There are also Inuit, and there are Métis peoples. Neither Inuit or Métis were included within the original Indian Act and therefore fell outside of the so-called federal jurisdiction and basically were left in a serious gap for decades. So it was 6 decades before the Inuit finally managed to get a reference in front of the Supreme Court to confirm that they did fall within Section 9124, meaning the federal government had responsibility for Inuit. But it was there, or up to that point, just not exercised. The next Canadian Constitution Act along this realm of recognition was in 1982. In 1982, the government recognized that there were 3 Indigenous peoples in Canada, again, First Nations, Inuit, and Métis, and recognized that the rights of First Nations, Inuit, and Métis were thereby recognized and affirmed. And that's basically about what it said. In this country, we like dialogue, and so the Constitution also obligated 3 constitutional conferences, which, to make a long story short, too late, didn't really amount to very much. So throughout Canada's history, you have First Nations governments, which were created by the Indian Act, asserting or attempting to assert any number of rights, rather through treaty, through litigation, or through direct assertion techniques. Right now, there are some 630 plus, it's really 633, I think right now, First Nations in Canada. The Métis Nation is one nation, but they actually have up to 4 and potentially 6 regions. And the Inuit right now are basically sitting with 4 regions. Again, each region with its own treaty and with its own governance arrangement. However, for First Nations, personality issues are a little bit more involved. Because the Indian Act created First Nations governments, there are any number of hereditary governments which ran and continue to run to differing degrees as unrecognized within Canada. Many of those hereditary governments would argue quite strongly and properly that they themselves constitute the legitimate representatives of those First Nations or those Indigenous nations from the pre-contact era. Whereas the First Nations themselves are essentially imposed by government legislation or really administrative delegates of the Canadian state. Which is a fair argument to make. It's also fair to point out that in the several decades since Canada was created, First Nations have really evolved to a point where they, while being creations of the Canadian state, actually are capable of exercising rights beyond whatever the narrow statutory mandate they have under the Act are. Again, it's in some ways quite confusing and can be quite muddled, which is one of the reasons why it's really hard to give people straight answers about, how many First Nations are there in Canada, or what are the roles of hereditary councils vis-a-vis First Nations. And these are not dead issues, so they're quite live. They continue to play out on virtually on a daily basis. And it's only because some First Nations have organized themselves where there's quite a bit of tension between hereditary councils and First Nations governments. In other cases, you have hereditary councils and First Nations governments working in tandem in order to assert First Nations rights. And in other instances, you have relationships between First Nations and hereditary governments that have either deteriorated or are cyclical, sometimes improving, sometimes deteriorating. So that makes for a fairly complex a series of arrangements. In terms of sovereignty, as Indigenous peoples themselves seek recognition, one of the clarion calls, particularly of the First Nations Métis rights movements, have been defining and seeking recognition of sovereignty for First Nations. So Canada in general is not a state which recognizes inherent sovereignty of First Nations, Métis, or Inuit governments. If you want to secure sovereignty, options could include negotiation with the federal government. They could include potentially attempting to use litigation. They could include assertion techniques, which is to say that you simply assert your sovereignty and I suppose hope that the Canadian government doesn't impose itself on whatever you're asserting. Even in Canada, treaties, and many treaties in this country are viewed through the context of the state as documents of surrender or release, hence the use of the term cede, release, and surrender clause within a treaty. So for the federal government, many of the treaties that have been drafted with First Nations in particular are seen as documents which result in the complete surrender of sovereignty, if it had ever existed even. So they don't even necessarily acknowledge that it had. Surrender of the ability to claim such things. Whereas for First Nations, they see the ability to enter into treaty and the fact that treaties were entered into as a confirmation of both sovereignty and the self-determination of the treaty nations themselves. So it's a really major gap between the state and where First Nations themselves are. And on top of that, there really hasn't been within this country much space for dialogue, at least not on those points. So what many people tend to do in this country is to have lots of discussion, but the base point and the baseline for those discussions often is not inclusive of any number of issues which First Nations, Métis, Inuit in particular would want to put on the table. So for example, I would want to put on the table that there's some sort of an inherent right of, say, self-determination, sovereignty, or self-government. The federal government is, for a variety of reasons, unwilling to basically have a free-ranging discussion about what recognition of sovereignty or self-determination might be, and is more interested in having a much more limited and scoped-in discussion. Interestingly, usually about to what extent can First Nations, Inuit, or Métis governments engaged in federal service delivery for the federal government. So, I mean, what I would say on that is that even within the realm of treaties and how First Nations assert their rights to, or what they would term as their rights of self-determination, is a really, really major divergence. So in 1973, the Supreme Court of Canada noted that it's within the realm of possibility that one might be able to demonstrate Aboriginal title within Canada. So what that really means, to not be technical about it, is that it might be possible for First Nations to secure land rights in this country through a court without those lands being ceded to them by the state. Before that decision came down, the general thinking in the law was that First Nations land rights were not cognizable at law. That is to say that you couldn't recognize some kind of an inherent land right from First Nations. That land right had to be recognized through the state. In other words, you would have to, as a First Nation, surrender lands to the state or your claim on lands, and the state could then grant you lands, which then constitute, in the case of First Nations, a reserve. The possibility that First Nations would be able to claim territories in courts, particularly territories that had not yet been covered by treaty, created, I would say, a very strong incentive on the part of the Canadian state to initiate modern treaty discussions, so post-1973 discussions with First Nations and particularly Inuit over fairly vast swaths of territory, especially within the Canadian Arctic, within the province of British Columbia and within the province of Quebec. And it's just because most of the lands within those regions, for whatever reason, had not yet really been subject to treaties. Because of that, you actually have within Canada a range of discourse that runs in assertion techniques from modern treaty First Nations and self-governing First Nations. They've successfully negotiated substantial rights from the state and have a relationship with the state that's very firmly, I would say, represented in extremely lengthy and technical documents known as modern treaties or self-government agreements. At the same time, you have First Nations in particular with older treaties that are out there that themselves are looking at more like the spirit and intent or the nature of the relationship with the Crown as being one of honor, and that what they are actually seeking is recognition and enforcement of the treaty relationship. And in some cases, I would say like the actual obligations within the treaties, particularly with respect to lands and to annuities coming from the treaties. And then you have a number of First Nations out there, including mine. So I'm from Akwesasne, which is on the border between the United States and Canada, which don't necessarily rely so heavily on a treaty relationship, so much as we rely more on our inherent ability to regulate our own affairs and our own territory. And the fact that we haven't surrendered our territory to Canada is evidence for us that it's our territory. In other words, if it hasn't been taken away from us, it should still belong within the community. And Canada takes exactly the opposite view, in the sense that it's within Canada's territory, then Canada should have some degree of control over it. Hence the reason why there's a fair amount of negotiation and litigation within Canada. So I suppose I would kind of leave it at that, except to say that the current framework for asserting Aboriginal rights in Canada rests really strongly on the ability to have some degree of continuity, really with either pre-sovereignty, so pre-Canadian sovereignty, or pre-contact culture, depending on the nature of what it is that the First Nations are trying to claim. The idea that there's some very, very broad-ranging self-determination right out there from the court's perspective isn't necessarily completely amenable or completely within the realm of what they're thinking about. Although when you marry, say, self-determination or sovereignty to title and to land rights, there's more judicial appetite for taking such matters on. It's extremely contradictory, and it's extremely difficult to understand only because the two main points, at least within Aboriginal rights law, in terms of determining how Indigenous peoples should press for their rights, are on one hand the concept of reconciliation with the broader Canadian state. We're talking about reconciliation of distinct cultures, distinct laws, distinct societies, at the same time that you're actually arguing about that distinctiveness. In other words, what founds an Aboriginal rights claim or an Aboriginal title claim is often the fact that the First Nations, the Indigenous peoples themselves, were living distinct of Canada. So on one hand, we're looking to identify the differences between First Nations, Inuit, Métis, and the rest of Canada, at the same time that we're trying to reconcile them in some kind of a judicially mediated organization. So I guess I would basically leave it there, except to say that really all Indigenous peoples in Canada, First Nations, Inuit, and Métis, tend to take an approach where we seek both to litigate and to negotiate with Canada. So the idea is that dialogue, whether that dialogue be in a political arena, judicial arena, or even a policy arena, is the best way to proceed forward in terms of seeking, I would say, meaningful recognition of First Nations rights. So in general, and there are several, I would say, notable exceptions to this general statement, the preferred path for most First Nations is actually one of negotiation, but negotiation on the basis of recognition of the fact that we exist as human beings and as peoples, that we have sovereignty and rights which need to be recognized by the Canadian state, and that we actually deserve and the dignity and respect that comes from those first two points of recognition. Those dialogues and that recognition is very, very hard to secure, particularly given the fact that the state itself is engaged in a number of, I would say, fairly assimilationist behaviors throughout its history that have established assimilationist structures. And so the other little thing that you try to do in Canada is to dismantle a lot of that assimilationist structure, not just for the sake of doing so, say, like being politically correct, but because if you can't dismantle the really colonial and assimilationist structures that underlie a lot of Canada, you really can't have the kinds of conversations that First Nations and frankly Canadians need to have to move past really our shared colonial legacy. Thank you.
Thank you. Thank you, Will. I'm wondering, before we address some questions from our audience, whether either Jerilyn has a question of Will or Will has a question of Jerilyn that were raised by their presentation, or some likeness or difference that you might wish to highlight having heard the other speak. Will, since you've had the floor, the mic most recently, do you have a question for Jerilyn or an observation on Jerilyn's presentation that would be helpful for our listeners?
It's the big observation that I would have on Jerilyn's presentation was actually one of her core and my core points, but it really is just the importance. I mean, in the United States, it seems like sovereignty of tribes is itself recognized, which is really something that First Nations in Canada are struggling for just as a base proposition. What I'm curious actually are what are the challenges that come from that? So she mentioned plenary power, but I'm just wondering if there are others, just because we assume, or many of us assume here, that if we actually got recognition of First Nations sovereignty or self-determination, that would resolve a lot of issues. And I'm not entirely sure that that's been the case in the States.
Jerilyn, any observation? And then you could pose a question if you'd like to, Will, and after you respond.
Yeah, thank you. That's a great question, Will, because obviously there are so many hurdles and obstacles and backward slides. I think the biggest problem for tribes is having control of their resources here in the United States. And I mean resources very broadly. Natural resources, oil and gas, minerals, uranium, resources including people, land. So the ability to control and regulate it and to turn it to their own benefit so that they can do the nation building they need to do to strengthen their community, develop economically, educate their folks. So control of the education system, control of the try to stem the tide of loss of language and culture. But the control thing, and so many times when the United States passes a law, they forget about Indian tribes. And we have gotten to the point where unless Congress specifically mentions tribes and says that a law is applicable to them, it's not. But that was a really hard fought place to get to. So there are so many things. You know, the tribes own about 4%, I have those numbers, quite a bit of the nation's wealth of oil and gas reserves. Just as an example, coal reserves, it's like, it's up. I don't have those figures right in front of me. Uranium, like 30%. By all these measures, tribes should be so wealthy, and they're not. And, you know, by these measures, even though they've put us on these remote reservations, in some ways that turned out to be an advantage. So when tribes can gain control of their resources and manage them well, then they can turn things around. I'll give an example of the Southern Ute tribe in Colorado. In 20 years, they went from being one of the poorest reservations to one of the wealthiest. And they have secured the future of their tribe for a long time. And the way they did it is they took control of their oil and gas infrastructure. So they did their own, so they cut the Bureau of Indian Affairs out of it. So in 20 years, they have diversified their income stream. They own all kinds of businesses all over, for sure, the United States, because they've been able to turn this oil and gas revenue to good and reinvesting it in the tribe. Now, not every tribe would have that capability necessarily, and not every tribe has that kind of a resource, but to have the control of it, to regulate it, to decide what's going to be done with it, it just really turned their whole economy, their whole reservation, their whole education. I mean, they can provide their citizens with what they need to become successful in the world. So that kind of control. So those kinds of challenges still exist. Of course, tribes have been so debilitated by the federal policies that it isn't easy to get back to that starting line. It's just not. So even having resources, now my tribe has no resources. We live on a 6x12 reservation and we have 47,000 tribal members. And they don't all live there, but probably 15 to 20,000 do live on or near the reservation. And there's no resources. But yeah, control of resources, and also the whole environmental thing, and the ability to develop economically. And another example I want to give you is in the environmental regulation field, the National Environmental Protection Act, huge. You really can't do a federal project or a project that uses federal money or that requires a federal license. You can't do anything that will impact the environment unless you go through this NEPA process, this environmental review process. Well, there's a baseline in that process. So you find that baseline and then you measure the impact your project is going to have on that baseline. And if it's cost too much economically or in other ways, economics is the biggest measurement, then you might not be able to do your project. So for Indian people on reservations where other people have had the benefit of our resources, they've already done all their economic development. They've gotten the benefit and they've done their environmental damage. And so the native people come along and they want to do a project. Their baseline starts with all that damage that has happened before. So they have a much bigger hurdle to get over to have their project go forward. And that inhibits tribes from being able to develop their resources and their reservations in a way that will make them economically more viable. So these kinds of things, just they're every day, you know, it's just, yeah, we don't have control We don't have control of our resources, but it's coming. It's coming under the Indian Self-Determination Act, which really became effective under President Nixon in the 1970. And that's been the policy ever since, you know, we've had these wild swings of federal policy, and so much of it was assimilationist or exterminationist. But under this new policy, it does allow for tribes to have more say about the way they engage in development and use of their resources, and over all kinds of things, including the other kinds of things I mentioned: education, language, their children, you know, what happens to their kids. So yeah, that's I don't know if that's a very helpful answer. It's all very complicated. That's like Will describing the relationship in Canada between the federal government and the Indigenous First Nations. I just feel really discouraged, Will, in listening to how the federal government is not willing to meet the Indigenous First Nations at the place of they were once sovereigns, or they still are. I mean, it just defies my human understanding that there wouldn't be a recognition that these First Nations were self-governing and had fully functioning societies and ways of controlling and their people and educating them and maintaining peace and everything that societies needed. And to kind of not accept that is just beyond my comprehension. It feels like an uphill, really big uphill battle, a Sisyphusian task for First Nations in Canada. But at the same time, sometimes we look longingly at Canada over here and we say, oh, wow, they're doing so much better, you know, than we are. So, and I think that goes into the First Nations category too. And of course, I get excited about the whole Métis issue because we call ourselves Michif, and that's the same as Métis. On my reservation, we're a mix of, you know, French and Chippewa and Cree. And we have that same Métis culture. But for us, it's just a culture. For Canada, it's a Métis nation. You know, our ancestors fought Canada to become be recognized as a nation, and they succeeded. You know, Louis Riel, Gabriel Dumont, they succeeded in establishing a nation. So that, to me, that's just so awe-inspiring. So not a question, Will, but I feel like I could sit across the table from you and talk for days.
Yeah, I must say, I make it sound somewhat dire, but it's because in Canada, well, we're framing the issue as one of sovereignty, and sovereignty is a really, it's a big issue in Canada, and it's hard to grapple with, and it's not just an Indigenous issue here. So it's worth noting that Canada also has a little teensy sovereignty problem with Quebec. And has had a problem with Quebec in terms of grappling with Quebec's sovereignty and national identity for a long time. So it's one of the things I suspect makes that particular term challenging, and it's especially challenging, again, because there's a lot of First Nations, including mine, that are quite attached to sovereignty discourse. The thing that's really beneficial about Canada right now is that essentially a lot of things can be put on the table. So after the Section 35 was recognized in the Constitution, I mean, it took a long time, for example, for the Métis Nation to receive confirmation that Métis rights were within the scope of Section 35, despite the plain reading of the Act. That was 20 years after the Constitution Act in 2002. Yet, in the span between 2002 and today, there's been some serious and major developments, very beneficial developments with the Métis Nation. They actually are able to and have engaged the government of Canada in helping to define out what those rights are. So the thing that makes Canada interesting is it's less about, say, Parliament chipping away at, say, like First Nations or at Section 35, and it's much more about First Nations, Inuit, and Métis trying to build up what that actually means, while at the same time, as I mentioned, really trying to deconstruct some of the more odious aspects of Canada's past. And to be fair to, I would say, Canadians of all political stripes, you know, a lot of Canada's history around Indigenous peoples is not really that good. And I would say that there's a broad national consensus that a lot of the things that happened in Canada's past were not good, and in fact were quite bad. The issue is basically how to move forward. And that's actually where we tend to get into the really difficult discussions. And sort of, as you mentioned, a lot of it does revolve around natural resources development and environmental considerations. Thanks.
Thank you both. I'm going to try and field some of the questions that are coming in. There's a lot of interest. I think one of the first questions that I had, which someone raised very early on, is for Jerilyn, and that has to do with speaking about federal state recognition versus non-recognition at all of Indigenous peoples as having some rights. And we were hearing Will saying that the creation of Indians was as a result of the Constitution in Canada, whereas here we're talking about inherent sovereignty resting with the tribes, making treaties, and that confirmed, and Will said that as well. But at this stage in federal relationships and state relationships with tribal nations, what difference does it make, or why is it important to have federal recognition? Or what difference does it make if you have federal or state recognition in terms of what that means for tribal relations with government or sovereignty?
Sure. Well, it's interesting because there's a tribe in California that I think they're called Esalen, and they were just returned some of their Aboriginal territory. And I read that they are not interested in federal recognition because they feel like it will somehow inhibit their ability to be who they are, to maintain their own culture. And that's admirable. And there are those people, and I don't want to open a can of worms on this, but there are those people who think federal recognition is sort of a product of colonialism. So we have to be recognized by the federal government to be who we are. Well, it's complicated. And with federal recognition, tribes have been placed in a position of having their hands tied in so many ways with respect to resources. And I mean, our cultures have been crushed and destroyed. And my tribe has no way for all the people there to have a job and earn a living. And if you want an education, before we started our tribal college, you had to leave the reservation, and you still have to for any sort of an advanced degree. So everything about tribal existence now is handicapping. And federal recognition at least gives you some benefits under federal laws, federal programs, support for tribal programs and tribal sovereignty. And it is a government to government relationship that goes through all federal agencies, everything in the federal government, whereas a government to government relationship with a state is just that. It's just one state. So I think, you know, you'd have to balance the what you wanted to get. You know, if you felt like you needed to have that federal relationship, and maybe if you were well enough off tribe, you know, and independent enough, you wouldn't need that so much. But what else was I going to say about that? Why that's so important? Oh, my thought just escaped me. But that's kind of basically it. And there are only 16 states that have tribes within them that are federally recognized, and these 400 tribes who aren't federally recognized. Oh, I know what I was going to say. So to gain federal recognition, the tribes have to do what Will was talking about for the Canadian tribes. They have to prove continuity of existence from contact time. And they have to prove continuity of their government, their tribal government, their culture, they have of their society, basically. And that's not easy to do when you think of how many of us are not here anymore. 95% of the Indigenous people who were here at contact are not, they died or were killed. Tribes were moved. The Ho-Chunks in Wisconsin were removed 11 times.
Exactly.
Rebuild your society every time is just really, it's just decimating. It's so crushing, and it's nation crushing. So there's a long road there, and you need all the help you can get, and that means sometimes you have to have the federal government.
Yeah, like a pact with the devil, sort of.
Well, they're not all bad guys.
Well, here's a question that flows from what you were just saying, though. So the tribe that just recently received land back, you didn't say from whom, but they'll now have land that is theirs, over which, to me, sovereignty would mean that should the motorcyclists want to drive through their territory, they would be fully right in preventing that happening. But if they aren't recognized by either the state or the federal government, how is that sovereignty recognized by others? In other words, the treaties bespeak a relationship between equals, and without some form of other people recognizing that you're a country, for example, in the United Nations, you aren't one until you gain that recognition. So where does that come from in this particular case that you cited, which I thought was interesting?
Yeah, and I don't claim to know very much about the Esselen peoples. I think their land was probably private land. I don't think the federal government was involved there, but it was in their Aboriginal territory, so it was their Aboriginal land. I think you're absolutely right. As I understand sovereignty, every sovereign nation isn't equally powerful. To say that tribes are domestic dependent nations doesn't mean they're not sovereigns. Certainly, we can all think of countries in the world that are more powerful than other sovereign countries. It doesn't mean you don't have sovereignty, but you do have to have that recognition. I think the Esselen folks probably have the people and they have the territory, and maybe they can build a society, and maybe they already have one that they can just put on that land. But if they don't have recognition by the state or the federal government, then the sovereignty depends on that. It does. You're absolutely right.
A question was raised about land ownership. And I think this may be one of those, it varies. And for one thing, we can definitely say it's complicated. And the fact that you and Will could sit together and talk about these issues for days, I totally get that. And I think our viewers do as well. There was a question about, did the tribes, and this may vary from tribe to tribe, have a practice of land ownership before? I'm sorry, I'm trying to read chat at the same time as I'm going through this. Have a practice of land ownership before the invasion of Europeans.
I'm going to let Will have first say if he wants, but I can certainly respond to that as well.
I think that's a question for both of you, probably.
Sure. Can take a crack at this, I guess. Yeah, clearly it varies. One of the little challenges that I have with ownership as a concept is just that I would say for a lot of Indigenous peoples, lot of indigenous peoples in North America, certainly, um, the concept of ownership is at best awkward for indigenous peoples, and it's only because the relation. So the way that I would look at my relationship to, say, like a territory is less one of ownership over the territory. It's much more about responsibilities to the territory, responsibilities to other people. So you don't think of yourself as, say, like owning your family. You have relationships with them. The same could be true not only for the territory, but again for the living things that are within it. And really, like, everything's connected, so it doesn't just begin and end at your territory. Like, really, the world as a whole is connected through the territory. So that doesn't mesh well with traditional European concepts of ownership. And so, like, the idea itself, or I should say the ideas, don't mesh well. Now, oftentimes, though, when people are talking about ownership, really what they mean are issues like possession or control, at least for certain purposes. And clearly, a lot of First Nations in particular had fairly intricate notions of control, particularly in terms of when a particular nation's territory ended or another's began, who had rights to, say, pass over or shared hunting territories. One of the interesting little challenges in Canadian law is, because reconciliation is one of the guiding objectives of our law, in order to found an Aboriginal title claim, again, under Canadian law, and some use litigation as a means to secure their rights. Again, others use negotiation, and you'd have still other groups like, say, me, saying something more along the line of, well, if nobody can prove that they took it away from us, then it's still ours. In other words, it's just direct assertion. For those that go the litigation route, one of the things that they do need to demonstrate is that they occupied and controlled and possessed territory in a way that's relatively similar to English common law notions of property. And the reason for that is, in order for the Aboriginal title right to be cognizable under Canadian law, there has to be some semblance between what the Indigenous peoples are claiming as a title right and what Europeans or what European notions of property are. So whenever you see First Nations claiming title, they are claiming that pre-sovereignty, so before the Canadian state was formed, they were having a relationship with a set of territory collectively, mind you, which was similar enough to a Canadian or to an English property law right that Aboriginal title would vest in that nation. And just not being able to resist putting some ambiguity into this. One of the interesting points is, again, the Calder case was in 1973. In 1997, there was a case called Dalgamuk. In that case, I was discussing about First Nations being recognized through the Act. In that case, the Hereditary Council actually made the claim for title. And it's difficult to say that they necessarily won the claim, but it's fair to say that they didn't lose the claim. That's consequential, because then that means that Hereditary Council itself becomes the title holder for the constitutional Section 35 right, and is probably in a good position to negotiate a treaty if they so desire, or they could continue to litigate, but they have sufficient juridical personality to bring that kind of a title claim. So they have the land rights, but there's still First Nations in the area for that same nation that have the primary relationship, mainly with the federal government, and then also, potentially to some extent with the provincial government. So just to make it really complicated, to throw out that juridical personality issue, but at the same time, whenever you see that kind of a claim in Canadian law, one of the things that First Nations have to demonstrate doesn't have to be identical to a property law, right? And it doesn't have to be like individual slots of property, but there has to be a relationship that's sufficiently similar to how particularly the English viewed their relationship with property during that same period to be able to found the right. Thank you.
Thank you. Jerilyn, did you have comments on that you'd like to?
Yes,
brief comments, because we've got a lot of questions and little time.
said, that the relation to land is quite different, and it's really kind of based on what you need. So in Aboriginal title, there's a requirement that you have continuous use, occupancy control, and exclusive. There has to be an element of exclusivity. And Will just explained so beautifully how that doesn't really happen with Indian tribes, because while they certainly knew their own hunting and fishing grounds, and they had their villages and their cornfields, you know, and their crops and so forth, they shared. So there were overlapping areas of use for various purposes. So it is a very hard thing to marry those concepts and prove the European mind view of property and make that fit into the Aboriginal view. So, yeah.
Well, as we well know, as Will has said, there are, and others as well, there are tribal nations that transcend the Canadian-US border. And the question is, well, what happens or happened when a tribal land spans both the US and Canada? And that maybe depends on the individual situations, but we certainly know that's true of the Dakota and the Haudenosaunee and others. Is there a response to that that could be stated briefly, or is that one of those very complicated questions?
I think Will's better equipped to answer because he has such personal experience within his own tribe. He's like going, oh no, not again. I know. Yeah. No, I mean, it's important to understand these concepts. My tribe, we have, you know, Cree and Ojibwe relatives all over in Canada. We go to Winnipeg. I mean, we see our tribal names, and I'm sure we're related to a lot of those people, but the border divided us. And our land, we don't have land in Canada, and we don't have a cross the border thing like maybe, what's the tribe by El Paso?
Oh, right.
Isleta del Sur, and the other little tribe, you know, they do have that, just their lands just sit on the border. So that's my answer. We're split. We're United States citizens. We don't have land in Canada.
Well, one of the reasons why instruments like the United Nations Declaration are important is because it recognizes the importance of being able to maintain relations across borders at the level of the nation. So for Lakota, the Dakota for sure, for the Haudenosaunee similarly, bisected by a border, it's really critical to ensure that we actually have the ability to maintain relations across that border, recognizing the border itself is often imposed on Indigenous peoples, frankly, without consent. In general, I mean, I come from a community that's actually literally bisected by the border. So half the community is a tribe, a federally recognized tribe. The other half of the community is generally considered to be a First Nation. And then we have a large number of people that reject the notion of the border altogether and don't affiliate themselves as citizens of the United States or Canada, travel on their own passports. And that's, again, that's out of, that's a very strong assertion-based stand. We're sovereign people, and we never surrendered that sovereignty. We never consented to the border, therefore we're just gonna go ahead and travel on our own passports, the way those people would think about it. For others, it's a matter of you're, say, like a First Nation, you want to be able to go to the United States. That's part of the work that many people in political advocacy do, is just try to facilitate easier border access for Indigenous peoples, particularly in the United States and Canada. But this is a global problem, so it impacts Indigenous peoples worldwide. I could talk to as many people who have problems between, say, Finland and Russia as between the United States and Canada, which is, again, the reason why the global instrument is really important on this point. And it's also important to recognize that this isn't people wanting to disrupt or dismantle the state, the concept of the state. It really is about just ensuring that we have the ability to continue our cultures as distinct peoples. Thanks.
Thank you. So there's a question of that I think is important for both people, and we've had questions about this. If you cannot, if the tribal nations, indigenous peoples cannot control their own resources, how is it possible to even speak about sovereignty? Doesn't that mean that you have control over resources? And we have skirted over the doctrine of discovery and how that complicates everything. But I think people will be, if they aren't already aware of it, will be learning about that and should. But I think the question is fundamental. If you can't control your resources, then what does sovereignty mean in that context? Maybe it's almost not a hypothetical question, but that kind of question that you can't really ever answer.
Rhetorical.
Rhetorical, thank you.
Well, this is, for my part, that question, it's a very good question to ask, because that question is fundamentally the reason why there's so much conflict, either juridical conflict, rhetorical conflict, or direct conflict between First Nations and those who are supporting resource projects in territories which are contested. And again, it's just, if there's not recognition of Indigenous territories by the state, but we actually believe that we have control of those territories or responsibilities to those territories, then it's natural to assume that you're going to attempt to assert it. And often that comes in the face of a resource conflict. And again, that's common in Canada. That's not uncommon. So that does happen in a lot of other countries as well, particularly those where land rights run generally unsettled.
I pursue that with Jerilyn. Thank you, Will. You mentioned the Utes. I don't know whether you said skirted, but I think that's skirted the Bureau of Indian Affairs. And how was that possible for them then to gain control over their own resources? In what was the mechanism by which that was undertaken and succeeded?
Well, I don't know exactly, but they bought back all their infrastructure. They literally took the money they were earning and they bought back their transmission lines and their pipes, and so they became the owner of everything. And the BIA just didn't have anything to say about it after a while. So it was a very measured and a very purposeful thing. Plus, they had a lot of money to work with, a lot of resources.
But the question, I think, was if they didn't have initial control over this uranium, how did they gain control of it, or whatever I'm sorry, it was the oil and gas reserves.
Yeah, they used, well, the BIA, probably the mineral, some department of the United States and the BIA were managing their oil and gas production and owned all the infrastructure and held it for the tribe. But somehow they worked with, and if a tribe wanted to manage its own property, there are numerous ways to do that under the Indian Self-Determination Act. They can do that, but they went a step beyond because they actually took back complete control and ownership of their resource. So, yeah, I'm sure there's no law against a tribe doing that, but they let the BIA off of the hook there. And that's the best answer I can give you, because I don't know the machinations. I don't know the details of it. I wish I did, because it's a fascinating story. And what I've asked the Utes to do is to mentor. So when the Fort Berthold in North Dakota, where the Bakken is, where they're doing all the fracking in North Dakota, before they entered into all these leases for fracking, we got the Southern Utes to come up and tell them what they had done, how they protected their water, how they protected their lands and their roads, and what they did to make their project work, and how they diversified, and how to negotiate a lease with an oil company, how to protect their interests because they had been through it all. So my idea was that they needed to be mentors. They needed to tell the tribe their experience. Fort Berthold, the three affiliated tribes, Mandan, Hidatsa, Rickaroth. That's what Fort Berthold is, the Fort Berthold Reservation. They needed to share with them their lessons and how they did it. So I thought maybe it wasn't so important for me to understand it as to get them to those two entities together to try to figure something out. And, you know, and then it's up to them. And I don't think Fort Berthold has been as successful as the Southern Ute.
Thank you. We have many more questions from folks, all of which are good. One of which I thought was particularly provocative was a comment. A question for either Will or Jerilyn. What about critiques that seeking recognition from a settler-colonial government can't ultimately be an exercise in sovereignty because it doesn't entail full decolonization from the settler-colonial state? Do you have a comment on that, or is that one that just sits with you?
Full decolonization would take restitution. It would take putting tribes in the position that they were in before the United States took all their land and resources. And this is the state we're in today. I don't think we're going to have full restitution. We have what we have, and federal recognition is, in my mind, the best option. And yes, it's a colonized concept for sure.
Right. Some people were also mentioning they thought sovereignty itself was a colonial Western European invention. But yet there are things in international law that I think we would recognize that people have control over territory, and that's where sovereignty was not something that came from the West, but is actually part of belonging to the land. The land, we belong to this territory, to this piece of land. I would just like to ask, go ahead, Jerilyn, I'm sorry.
I just want to say that's a very colonialist thought to think that Europeans invented sovereignty.
Well, this is Will, actually. That there is a guy named Anthony Ainge who wrote a pretty good book about sovereignty, imperialism, and colonialism. But I mean, I wouldn't completely discount the view. I mean, sovereignty may well have, and in my view, it was created as a concept, as an idea to support essentially European expansionism, not just in the Americas, but really throughout the globe. Like the concept of sovereignty, and if you think about it, like you're saying, like we need to have recognition, say, from other states or from the federal state or from provinces, and that's an essential criteria of what it means to be a sovereign country. That may or may not be the case, but you have a lot of scholars out there that would suggest that actual statehood as a legal criteria does not depend on recognition. It's a political criteria, which only really feeds the notion that sovereignty and recognition really are about colonial control. For my part, I mean, 633 First Nations is part of the Assembly of First Nations. There's always those that would seek like a direct assertion technique, who espouse those views. I think that's completely valid. At the same time, I don't know how you actually make any degree of progress unless everybody's actually willing to have a conversation where you can put everything on the table. And that means for Canada to come to the table with some fairly, that's where I focus my advocacy, with some fairly flexible positions. But it also means that those Indigenous peoples that would discount the very notion of sovereignty or the notion of talking to the state really need to have enough flexibility to be able to have a meaningful dialogue with the state about how they would see going forward, even if they want to go forward in such a way where they don't recognize Canada and Canada doesn't recognize them. There still has to be some sort of a dialogue and a resolution of that, even if it's a matter of everybody agreeing like to disagree. that we're going to move forward together. And I mean, it's the kind of thing that I think most of those governments, those First Nations governments, would see that they owe to their citizens to build a better future. And I would hope that the state as well would hope would come to such a table, just if nothing else, really for the peace of the region. So I mean, I don't completely discount it. I do think it's a valid consideration. I don't think it's like without merit at all. It's not the universe I live in, though. So like I say, it's the kind of thing that I tend to support, but my game is mostly about government policy. Thanks.
So the book you mentioned, Will, that was beautiful. Thank you. And thank you for.
Could you write it in chat for everyone, please? That would be always helpful because we're looking to share resources. I recognize that our time is up, but I would love to give people, if they're willing to stay with us for a bit longer, to have you offer some concluding thoughts. Because honestly, trying to cover a topic of this degree of difficulty in only the short period we had is, it cannot do it justice. But if you could give us some takeaways that we might reflect upon, I think that might be helpful. Will or Jerilyn, whoever is prepared.
Yeah, I'm ready. One of the questions that you put forth to us was about Indian identity and how Indians are identified and the benefits and so forth that flow from that. But I want to be sure that I do share that the identifying yourself as an Indian is a political and not a racial category. It's a political one. So that's been recognized by our courts here, and tribes certainly have always operated that way. So Indians are identified by either federal laws or by tribes. And really those are the only two valid ways. The federal laws for the purposes of federal laws and programs, and by Indian tribes for being a citizen of that tribe. And notice that there isn't anything in there that says individuals get to decide, because under a political category, you don't. Individuals don't get to decide that they're part of that political group. So the tribe does. So I would leave it at that.
That was a good point, and it finishes the question that one of the people raised, which was, do tribes get to decide their own membership? And that is the case, and that is recognized in the courts in the US. Will, do you have some concluding thoughts for the people who are listening?
Yeah, I mean, I'm kind of wanting to really rage now on construction of individual identity. Suffice to say that, like many of these other issues, it's a extremely live issue in this country. I would say this, and I mean, because it's a very much a loaded issue, because there are a lot of issues. There's no simple solution to dealing with identity. So simply stating First Nations should control their own identity apparently raises many of its own issues here that generate a fair amount of discomfort, both within the broader Canadian community and certainly within the First Nations community. What I would say, and I mean, again, I just close by again commending all of you for taking the time, for the organizers taking the time to organize, and for Jerilyn for taking the time as well to present. Only because really the only way to make any amount of progress on these issues is to have much greater understanding. And I mean, understanding is very much a two-way street, in the sense that it helps for First Nations, Indigenous peoples to have a better understanding of where the state is coming from, and also like where citizens are coming from, and vice versa. Obviously, it's much it's easier, and I should say it's easier, it's much more productive. We can't actually have any kind of meaningful progress or reconciliation unless there's much more understanding within society. At the time of many of the treaties that have been promulgated between Indigenous peoples in Canada, there was much greater understanding at the time, and over time, a lot of those early treaty relationships deteriorated as that understanding faded. Indigenous issues increasingly became invisible. So again, I just commend you for making many of these issues visible again, even if it's only within, the scope of the session, or it really does make more of a difference than you might expect. Thank you.
Thank you both so very much for being with us, and thank you all for listening and being with us with some difficult topics. I'm going to see what we might be able to do to answer some of the questions that did not get asked in the webinar itself. If perhaps Jerilyn or Will might be willing to respond to some of them in an email, we can make those available, but I'm not going to presume that. We've set this topic of sovereignty in order to establish some of the difficulty and the difficult questions that will continue to arise during the course of our webinar series in terms of how individual citizens who are non-native might be participating in a broader recognition of the issues facing people in Indian country, as well as people who are indigenous and living outside of tribal lands in cities and separated from their people. So the next time we will meet will be on August 24th at 7:30 p.m. Eastern Time. And we'll be looking at implementing the UN Declaration of the Rights of Indigenous Peoples, which has been ratified by both Canada, or I should say recognized by both Canada and the US, and how though the recognition of rights that inhere in Indigenous peoples are being recognized or used to increase recognition of the rights of Indigenous peoples in those jurisdictions where there's a mix of federal and state and provincial and tribal sovereignty questions. So until the 28th, I wish you a very good evening, and I thank you so much for participating. Good night.
Thank you.